90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is Attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to talk about age discrimination, how employers have to try to avoid it, and how employees may have rights to sue, what rights they have to claim age discrimination, when it's not discrimination and when it could be. Our special guest is Attorney Ruth Kraft. She is the chair of the employment law practice of Falcon Rappaport and Berkman, with offices in New York City and Long Island, and she's an expert on this issue. She lectures many bar association groups and others about the latest trends in employment law, and she primarily represents employers, and she's also a former New York State judge. Ruth, welcome back to Law You Should Know.
Thank you so much, Ken, and thank you for asking me back. It's a pleasure.
And I know there's so many areas of employment discrimination, but for today's, and there's a podcast where you're talking about other issues, but for today we're going to focus on age discrimination, what rights employees might have, and what pitfalls there are for employers. So just start out by talking about some of the grounds for age discrimination to avoid in 2024.
So, it's funny because we're both sitting here and I think we're both over 60. And I asked myself today, is 60 the new 40? I remember what my husband's grandma looked like. She looked like a grandma with lace-up shoes. I'm not like that. I am working. And I think I'm a lot better at what I do than when I was 23 right out of Yale Law School because of the years of experience. So I asked myself, why was the ADEA, the Age Discrimination in Employment Act, the federal law, what was its paradigm? It actually applied by statute to workers who were over 40. And I say 40, that's nothing. And it reminded me, when I was preparing, I thought there was a phrase, don't trust anyone over 40. It turns out it actually was, don't trust anybody over 30. And it comes up actually in 1964. 1964 is a seminal year. It's the year in which Lyndon Johnson managed to get Title VII of the Civil Rights Act, the entire Civil Rights Act, passed by Congress. That was a revolutionary year. But oddly enough, the classifications for discrimination didn't include age. What happens 3 years later is that Congress enacts the ADEA, the Age Discrimination Act, separately. And it isn't the same. And it's so interesting. The law itself, the federal law, prohibits the discharge, failure to hire, demotion, classification, or the deprivation of employment opportunities or adverse effects on employment status based on age. And it applies not only employers, but it applies to unions. Do you remember union halls where people would show up to see what was available? And it applies to employment agencies, except those based on bona fide occupational qualifications. For example, if you had somebody apply to be a police officer, a fireman, and they have to lift a certain amount, be able to run at a certain speed, that would be a bona fide occupational qualification.
So you might not be able to apply to be a police officer,
right,
or join the Marines after a certain age.
That's right.
But if you're a construction worker and you can do the physical components of the job, at least at that point in your life, is there any basis to not hire you?
No, not at all. And what happens is it must be on the bona fide occupational qualifications. So funny you mentioned that. Federal Express and UPS basically wanted to get rid of a lot of older workers because they have seniority. They may have rights in their union systems that are preferential to the younger people. And so they decided to test people on physical capacity all of a sudden in the last few years. And of course, the older people might have trouble fulfilling the terms of the test, although they're doing their jobs fine. And so both of those companies have been sued, Amazon as well. The way you have to think about the Age Discrimination Act, it's almost like the civil rights laws meet the Fair Labor Standards and employment laws kind of put together. And by the way, also, an employer can't establish a pension plan that cuts people off at 40 or at 50 in terms of employer contributions. You can say that you have a plan that cuts you off after 20 years of service, but that's not the same as an age cutoff. It can't be a blatant age cutoff.
And as lawyers, we don't usually get overtime, but in a lot of jobs, overtime's unavailable, and maybe it goes by seniority. Maybe there's some union rules or rules of the employer, so they are still entitled to their seniority, so to speak.
Yes, absolutely they are. The federal agency that's assigned the responsibility for dealing with age discrimination is the Equal Employment Opportunity Commission, the EEOC. In order to sue in federal court in a claim of employment discrimination based on age, you must go first to the EEOC. So this is a very interesting and tricky thing. People don't realize that if you do not go to the EEOC and if you don't go there in time, you now lose your rights under all of Title VII and the ADEA. And so in the old days, if you filed a claim with the EEOC, typically they would investigate. They might even conciliate, mediate, and resolve the case. But they are drowning in cases brought because of COVID. And so typically at 6 months, barring some extraordinary circumstances, they give you a right to sue letter and say, now you're eligible for federal court.
Without making any kind of finding.
Correct. That's exactly right.
And do you need that right to sue letter in order to sue?
You must have that right to sue letter in order to go into the federal system and invoke the Age Discrimination in Employment Act. You do not need the right to sue letter in order to sue claiming discrimination under state law or the New York City laws, the human rights laws. So some people try to use those laws instead because you can shorten the process.
And I just want to say, on you represent employers. If an employer is facing a complaint, are they better off, when they hear about a complaint, get a notice from the federal government? Are they better off seeing an attorney at that point?
Absolutely. I truly believe that the sooner the employer gets involved in it and seeks competent counsel, the better off they are. Now, it may very well be, and I just had this case on Monday, in which a woman wrote to the employer. They've discharged her because she didn't do her job well. And she wrote and said, you better watch out. I'm going to get a lawyer, and I'm 58 years old. And meanwhile, there's a disciplinary file, half an inch thick, describing how she didn't do her job effectively. And interestingly enough, the employers are over 42. So one thing in age discrimination, you typically evaluate not just how old you are, but who is the comparator. If I fire the 58-year-old and I bring in the 38-year-old the next day, what's going on here? And very often, because all of these situations in discrimination are completely anecdotal and they are unique, you really can't just take it on a superficial value. I think that what's happened, especially because of COVID and downturns in the economy, is that when people lose their jobs, they think, I'm entitled to that job. And one thing I want to emphasize is that we are not a right-to-work country. We are an at-will country. And that means that barring an employment contract, an employer has the ability and the right to discharge a worker for any lawful reason at any time.
And that assumes no discriminatory
That is
intent.
Absolutely correct. For any lawful reason.
Right.
I've written that into hundreds of decisions, by the way. It's one of the stock phrases that we use on the bench.
And on the flip side, if someone feels they're a victim of discrimination, are they better off going to a lawyer at the early stage, or the federal government, the administrative agencies will help guide them at that early stage?
So historically, if you go to, in New York City, the City Human Rights Commission, they are very overburdened, but they happen to be very pro-employee, in my opinion. The State Division of Human Rights had the reputation of being much more pro-employer. And I want to tell you why. The state and the city human rights laws were not aligned. The burden of proof at the city level is very low, and it used to be very high at the state level. And in 2019, the human rights law for the state was changed, and it was realigned to match the city. So I think now people have a better shot in the Human Rights Commission and the division, which the headquarters of which in New York are in the Bronx, actually, at Fordham Plaza. And they will assign investigators to every single case. The other thing you should know is if somebody gets that right to sue letter from the EEOC, they have 90 days afterwards in which they have to file a suit in federal court. If they want to go into federal court and it's day 91, they lose the right to sue. And I always say that some of these civil rights laws, what they give with the one hand, they take away with the other. And so if someone who's acting on their own behalf gets that letter and says, great, and, loses track of time, or they get the flu and they don't do it on time, they've lost their rights.
And at that point, once they get their letter, they might want to see a plaintiff's lawyer to evaluate their options. I just want to remind everyone, you're listening to Law You Should Know on 90.3 WHPC. We're talking with Attorney Ruth Kraft, and she is a partner at Falcon Rappaport and Berkman with offices in New York City and Long Island. And she is the chair of the employment law practice for that firm, and also a former New York State judge. And she's primarily represents employers, but she's giving information that's useful to both groups.
That's right.
You mentioned earlier it's important for the employers and the employees to keep records of other people, of their service, of any good, meritorious reviews or any not so meritorious reviews.
Absolutely important. So first, let me just say thank you, Ken, that I have a pretty big presence on LinkedIn. My last name is spelled Kraft, and if anybody wants to read my musings about employment law, which typically come out at least twice a week or in a crazy week more often, they can feel free to follow me on LinkedIn. The firm has a very robust webpage, FRBFrankruthbarry.com. FRBlaw.com. And in all of our specialties, we post information of interest to the public. It is important for employers to maintain good HR records on everyone, because very often someone will say, I got fired, you didn't warn me, I feel blindsided. And when people feel blindsided, then they say it must have been, but for a discriminatory reason, I would still have my job. And so what's very beneficial for employers is not just to say to somebody, you didn't do that right. I have a problem with this. You're coming in late all the time. But it really should be documented. My warning form is a single page. It's about as easy as it gets. But I think that employers who do not have HR departments and who are not up on this really self-sabotage when it comes to it. And that's a big problem.
And it's much more inexpensive to have a consultation with a lawyer like you to make sure they're following best practices and complying with any new laws than to be sued or investigated later on.
Absolutely. And compliance, look, in a difficult economy, nobody wants to spend money on compliance. But what do they say? An ounce of prevention is worth a pound of cure. And these litigations are painful litigations. Unless an employer has employment practices liability insurance, they are paying for counsel, they're paying for a judgment, and the plaintiff's bar is very fulsome in New York, and they work on a contingency basis. So some plaintiffs' lawyers will take cases that don't have merit just because it's an intimidation
and
tactic.
Perhaps it can be negotiated because
Absolutely.
Sometimes it's not worth the cost of litigation. So if they have to let someone go because of downsizing,
sure.
Can they look? What can't they look at? Can they look at age, productivity, technology, the future?
So you're raising something very interesting, because sometimes we see productivity and technology as a pretext for letting the older workers go, because the older worker may not be as fluent in the technological aspects of the job. They may have superb experience, institutional knowledge, and judgment. There's actually a law professor at NYU Law School who opined that companies were letting go the older workers to make the workplace seem more attractive to the millennials, Gen Z.
So they're more comfortable with their peers, supposedly.
Exactly, with a peer group. And that was absolutely fascinating to me. It is so tough. If you were going to have a big reduction in force, not just one person, but a group of people, you really need to have defined metrics. And of course, how you define the metrics could set up an age discrimination suit. And so one of the most famous ones in the country involves IBM. And IBM wanted to do a reduction in force. And what they did was they designed these matrices. And in the matrix of how people would self-evaluate and how the superiors would evaluate, they put a heavy emphasis on technology. And they actually did this, by the way, you're going to laugh, to their own HR people. So HR is not a computer-based discipline. And it resulted in the older, more senior HR administrators being let go, and they actually have a class action going right now.
And can they change the goalpost once you're there? Can they say you have to type 60 words a minute when it used to be 40? Can they say you must be familiar with this platform or this technology?
So if you were going to require someone to be familiar with technology, it's very helpful to actually train them on the technology, and also to recognize that the older brain is not as
nimble.
What's the word? Nimble. As adept, that it takes longer, that you need more repetition, and that may be required of the employer. That you put people on an even playing field. That, remember also, some people are auditory learners and some people are visual learners. And that goes to the issue, by the way, of disability. Because when you mention somebody only typing 40 words instead of 60 words a minute, most jobs in this country in a service economy are no longer machine workers on an assembly line where if you get too slow, you are putting your coworkers at risk. You could be putting yourself at physical risk of harm. In a service economy, trying to arbitrarily set a standard of 40 words a minute, looking at the keystrokes to decide who is quote unquote more productive would be really problematic. Whereas if you were in an industrial setting, then it might have a certain degree of relevance. Because of the Americans with Disabilities Act, which is a law that I do a lot of work on, the interesting thing for me is looking at discrimination, where people will say, I think I was discriminated against on the basis of age, and they'll describe their situation, and then they'll say, and I had to take 3 months off because I had a back surgery. I had a heart attack. And that's the point where I start to focus, both in defense or for plaintiff's side, on the notion of, tell me about this disability. When you returned from that leave, were you returned to the job under the same terms and conditions? Are you able to perform what are called the essential attributes of your job? So I'm going to give you a very simple example. Let's say you have an executive secretary. She has had a back surgery. And her problem is she can't bend down to the bottom filing drawer of a filing cabinet. But she can still type, she answers the phone, she takes stenography. And the employer says, I'm sorry, I'm going to have to let you go. You can't file. We would then look to say, is filing one of the essential elements? Does she spend half her time filing? Or is it a minimal thing that somebody else can do?
And would it also come into play how those limitations were handled with someone else? Maybe that they didn't have to do that?
Yes. And so you have to realize that in large corporations, the truth is that providing an accommodation, maybe if it's the highest file drawer, you provide a step stool. Maybe it's the older person who had a surgery and needs to have their desk closer to a restroom or not go up and down stairs. For a large corporation, these things are truly manageable. You can understand that in a place like this, where we descended a set of concrete stairs to get into our studio here, that there may not be a reasonable way for a small employer, perhaps, to modify the physical elements of the job. But if it can be done without a difficulty or a pervasive cost to the employer, then that is something that under the Americans with Disabilities Act that we would expect the employer to do.
And if they're returning after disability, or maybe their vision is not as good, the employer have to accommodate them a little bit?
Yeah, and also I'll tell you, I see it a lot in cases of loss of hearing. So the younger employer says, you didn't do what I told you to do. I was standing on the opposite side of the room and I told you, get me the file. You didn't do it. And the employee says, I didn't hear you. I couldn't hear you. Well, maybe that person has a hearing loss. And how do we accommodate that? Obviously, in a computer, you can enlarge the type. It may be that employer, upon learning that the person has a little bit of a hearing issue, says, I will give you that instruction and I'll send it to you in a text or an email, because that way you have it in front of you. So there are a lot of things that you can do. That's called the interactive dialogue. And the interactive dialogue is frankly where a lot of employers get into trouble. Now, that doesn't mean that if the employee asks for a specific accommodation, that the employer has to give that employee the accommodation they ask you for. But it means you have to dialogue back and forth.
And reasonable might be the standard?
I'm not sure what you mean by reasonable being the standard.
Let's say you need a better chair,
yes,
or a better computer, or whatever.
That's mandatory.
Okay. So I just want to remind the listeners, we're talking with Ruth Kraft. She's the chair of the employment law practice at Falcon Rappaport and Berkman, employment lawyers in New York City and Long Island, usually on behalf of employers. You're listening to Law You Should Know. If you missed any portion of this program, you want to tell someone else about it, just go to the website at nccradio.org, and you're listening to Law You Should Know on 90.3 WHPC Radio, the voice of Nassau Community College in Garden City, New York. And again, our guest gave her website, which has very helpful information and blogs, frblaw.com. We just have a few minutes left.
Ken.
So do you have any best practices for employers or employees to try to work out problems?
Yeah. Well, I think you just said it. Effective communication. It's important, if both sides feel that there is a potential issue, not to bury it and agitate about it internally, but to raise it with the employer or the employee, as the case may be. I think it's very important. Older employees tend to have what I would call, both sides actually, have loyalty issues. An older employee who's been at a company for a long time feels that they've committed themselves to that organization forever, and they don't want to feel thrown away.
And they want it reciprocated. That's
correct. That's absolutely correct. So when you get a new administration coming in, look, in business, it's very common for in the business world to say, I want my own team. I want my own people. I want to have the fit. That's the expression that they use. But you also have to look at whether this is code language for I want to work with somebody younger. And, look, there's a justifiable fear on behalf of people who are older, especially if they're in that sandwich generation. They're caught between their children and their parents, that if they lose that job, it may not be so easy to replace. And I think employers need to recognize that and focus on issues, focus on the fact that these issues are highly emotional. This isn't just a question of dollars and cents. It's very much a question of people's feelings under the discrimination laws.
And it's good practice for an employer facing this possible scenario to consult with counsel like yourself. And on the other hand, for employees who may think they're in the middle of this, to consult with employee lawyers to see what their options might be and
Right. And I want to say also that the tricky thing about the age discrimination laws is that unlike the other civil rights laws, they have what's called but-for causation. But for age, I wouldn't have lost my job. That is not the case under the state laws, the city law, or any of the other civil rights laws in which you can have what's called a mixed causation kind of case. Interestingly enough, when you bring a case under the ADEA, the standard, once you get into it, is simply a short and concise statement alleging discrimination on the basis of age. And we actually see that now in a case that's being brought by employees of Twitter. And as you know, Elon Musk buys Twitter. And it's been noted by the EEOC that 36% of the women who worked for Twitter felt very poorly treated on the basis of their age and quit, but 28% of the men. So there's this 8% gap. And the question is, does that establish age discrimination, that he had it in more for older women than older men? And of course, Musk does himself no favors, when he makes these public pronouncements. So it's really a fascinating subject matter. I'll give you another classic example. The drug representatives, the salespeople. That is a field in which it has been notorious that that the drug companies hire a salesman, gorgeous women, handsome men, and both categories young. So if a drug salesman is laid off, it is very difficult for them if they're over 40 or 50 to get another job. And so when you see big companies doing this, the numbers alone can help to establish what's called pattern in practice.
And sometimes they may lay off accountants or lawyers or others, professionals, because they have seniority, earn big bucks, and they may want to cut their expenses.
Well, I think in law and accounting, the experiential element of it, the fact that what it takes to really be a good lawyer is not just your education, but the years of experience, that I don't see law firms discriminating so much on the basis of age. Because if you take me 30 years younger, I always say I think I was a lot smarter academically, but I didn't have this wealth of experience.
There's no substitute for experience and contacts, but sometimes an employer may feel that rightfully or wrongfully.
Sure.
What's your final suggestion to employers and employees?
My suggestion to employers is don't shirk from compliance. I know that it costs money. I'm sorry it costs money. But everything that you do in terms of making sure you're in compliance with employment laws that are literally changing every week is the right thing to do. The state of New York, the government hides a lot of information about what it takes to be in compliance. And the only way you'll find out what those elements are is by having a lawyer. What I would say to the employee is be aware of your rights. Try not to be too judgmental. Recognize that everyone you work with is a human being too, and treat everybody with respect.
And if you have concerns on either side, just consult a lawyer to find out what your rights are and what facts you may need to gather.
Absolutely.
I'd like to thank our guest, Ruth Kraft. She's the chair of the employment law practice at Falcon Rappaport and Berkman. Keep in mind, whatever you've heard has been presented as legal information. It's not legal advice for anyone in any situation, and you must consult with a qualified attorney to review your options with you. If you want to hear the podcast or tell someone else about it, it's at nccradio.org. And thank you for listening to Law You Should Know on 90.3 WHPC Radio, the voice of Nass Community College in Garden City, Long Island, New York. And please join us next week for another program at the same time on Law You Should Know.